Okay. And where did your boyfriend, what is your boyfriend's name?
Carlos Hayes.
And do you remember what his address was?
It's 18674 Wexford.
Okay. And do you know the relationship to his house and the house that's occupied by the defendant, Mr. Smith?
It's on the same street, opposite side, opposite corner.
Would I be correct? It's approximately at one end,
One
opposite,
block. Yeah.
opposite ends of the block?
Correct.
Okay. Now, have you ever been in Mr. Smith's house?
Yes, I have.
And are you aware of the side door to strike that? Now, did there come a time at the evening that you heard any commotion at all in the area of Wexford where you were at?
Well, we were at home, we were watching movies. We did hear some gunshots. And approximately like 15 to 20 minutes after we heard the gunshots, which isn't unusual, there was a knock at the door, which we weren't expecting any company.
Okay. And who was knocking at the door?
Nistia.
And so did you get a chance to actually see her?
Yes, I did.
Did she say anything to you?
Objection, Your Honor. He hasn't laid any type of foundation to allow any type of hearsay exceptions in anything she would say.
Okay. Now, I withdraw that question. When she came to the door, did you have a chance to visually see her?
Yes, I did. She came into the home, and when she came into the house, she was ranting and raving and yelling.
Okay. Did you understand what her ranting and raving was?
Yes, I could understand what she was saying.
As a result of that, did you take any action?
Yes. She wanted to retrieve her car. After we had a conversation, she wanted to retrieve her car. I took her keys and I went down the street to retrieve her vehicle.
Okay. Now, was there any other discussion at all other than, strike that, whose idea was it to retrieve her car?
It was my idea to retrieve her car.
Okay. And you obtained her keys?
Yes, she gave them to me.
Okay. Did you observe any injuries at all on her at that time?
She had a little smear of blood like on the corner of her mouth, and she had a little blood on her knuckle.
Okay. Did she have blood all over her face at all?
No, she didn't.
Did she have blood all over her clothing?
No. We allowed her to go upstairs to the bathroom to use the bathroom so she could clean herself up.
Okay. Did she appear to be limping at all?
No.
Did she appear to have any obstruction of movement at all?
No.
Do you recall if any complaints were made?
She was.
Objection if it calls for hearsay. You offer for the truth. Objection. Hearsay.
Well, certainly the question is very vague. If any complaints were made by whom?
Well, while you were standing there in the doorway with Miss Thomas, do you recall any complaints being made?
Objection.
Again, that's the same question. Complaints made by whom?
Well, she has to just answer the question first. Were there any complaints? That's the question.
Whom?
Well, I understand that's the second question, but we have to ask her, were there any complaints first?
Objection, Your Honor. Answers will call for hearsay. He has not laid out any exceptions for them to come in.
Well,
I can't.
Just to ask a question, was any complaints made? I'm not sure where. I mean, the record has to reflect who she's talking to and who's making a complaint. And then we can make a determination if it's allowable, if hearsay, if it's an exception to hearsay, if it's non-hearsay, if there is some reason that the statute allows it to come in. I'm just hearing a question, and I'm not sure what the basis is.
Okay.
So, when you say complaint, what does that mean?
Did you?
Complaining of injury, complaining of someone trying to assault you, or complaining of what? I have no idea. It is just, it's a very vague question. And I'm not sure that the witness should know. I mean, I don't know if you've interviewed her or so and knows where you're going, but I certainly have no idea.
You were talking to Miss Thomas,
Yes,
and she had, as a result of that, you took some action to assist her.
yes.
As to the other than the action to assist her relative to her car,
Okay,
did you receive any other complaints or offers for assistance?
I did.
Objection, Your Honor, he hasn't laid any type of foundation for any type of hearsay to come in.
If you want to get something in that Ms.
Thomas.
Thomas has said, I guess you have to ask the question in such a way that we'll understand if it is something that is admissible or not. Just, and I don't know what that is, because I don't know where you're going, but certainly if there is something that you think is admissible, and it would be non-hearsay or an exception to hearsay, then maybe you should indicate what that is first, and then we can allow it to
Judge, I'm not asking it for the truth of the matter. I'm simply asking to establish what her course of action was as a result of her encounter with Miss Thomas at the door. That's what I'm seeking to get. I haven't asked one question about what Miss Thomas has said. I have not asked that question.
Yes,
We
it is.
can ask
You asked,
what
was there
she
any
did, what did she
complaint?
do?
You asked if there was a complaint, that would lead into, yes, I'm complaining of knee injury or hip injury or someone shooting or something. That is asking what, you know, and sometimes there are reasons things that can come in, but.
Well, Judge, if he says the only reason he's asking is to determine her course of conduct, he can just ask what her course of conduct was. You don't have to put that in to find out what she subsequently did. He's just trying to backdoor hearsay.
My response, Judge, that I haven't asked a question for this witness to say anything about what Miss Thomas has said.
Well, what would her response be if you asked?
Well, Judge,
you know what? We can stop right there. You can ask, were there any complaints? You can't ask what they were until you make a determination. If it's hearsay or not. But yes, you can ask the question.
Were there any complaints?
Yes, there were.
Okay. Now, were there more than one complaint?
No.
And so what was your course of action relative to the one complaint?
Based off of the complaint that she gave me, I told her to stay in the house because she wanted her car. I told her I would go and get her car because she didn't need to go back outside. Stay in the house.
Okay. Now, there came a time that you went to get the car.
Yes.
When you went to get to the car, did you notice anything unusual about the car as you approached it?
As I was approaching the car, I noticed there was something that was dark on the hood, and when I got in the car, I noticed that there was a hole in the windshield. I attempted to start the car, and the car wouldn't start.
Okay. And so what did you do then?
I got out of the car and locked the car and walked back to the house.
Okay. Now, when you walked back to the house, did you encounter Miss Thomas again?
Yes, she was in the house.
Did you say anything?
I told her that her car was inoperable. I could not drive it down the street to her. And she asked me why. And I told her that her car had bullet holes in it. And then she started.
Objection to the narrative and hearsay.
She can testify to what she saw in the car. She can testify to holes or anything she has personal knowledge of. She cannot testify to what someone else told her unless there is an exception or non-hearsay.
And what we're talking about here, not for the truth of the matter, but as to the course of her conduct which she's testifying to.
No, Counsel, because you already talked about the course of her contact, course of her conduct was to go get the car.
Well, Ed, now we're talking about a course of her conduct after she gets the car and goes back to the house.
So
She doesn't
why
go
does
get
she
the
need
car.
to testify and say what someone else said to her?
Did you go get the car?
I went to go get the car, but I could not drive it.
Okay. Now, when you gave her the keys back, did she do anything, Miss Thomas?
Yes, after I gave her keys back, she picked up my cell phone, which was laying on the table. And she used my phone, and she called 911.
Did you hear the 911 call?
Yes, I did.
Then what happened?
Then my boyfriend, Carlos, he was coming down the stairs, and he told her that he didn't want the drama at his house, and so he told her that she needed to leave. And so she was already at the door and on the front porch. We have a foyer. So she was between the front porch and the foyer, and he told her that he didn't want her there with all of the drama. And so she went ahead and she left, and he closed the door.
Now, did there come a time that Carlos left the house?
Yes.
Now, did there come a time that you spoke with Mr. Smith?
Yes, I did.
Did you observe Mr. Smith with a weapon at all?
No, I did not.
Did Mr. Smith, let's strike that. When you say you saw Mr. Smith again, where was he?
The first time I saw him was when I went to go get the vehicle. The second time that I saw him, he had come down to our home.
Okay.
Or Carlos's home.
When you say you saw him when you went to get the vehicle, where did you see him?
He was sitting on the side stoop where his side door is.
On the porch?
Yeah, it's like a little porch. It's what, 1, 2 steps, 3 steps. He was sitting there.
I want to show you what's been marked as Defendant's Exhibit number C, and ask you, does that refresh your recollection of where he was sitting?
Objection is relevant. How is where he's sitting on a stoop after the event relevant to probable cause at all?
I'm going to ask him about the gun. Was there a gun present?
A little leeway, sir. Get to it, though.
Does that refresh your recollection?
Yeah.
Well, she never said she needed refreshing anything. She said it was a stoop, and you introduced a picture to refresh her recollection for something she didn't say she needed refreshing on.
Well, Judge, this is the exhibit. I think it's an important exhibit. It's the entrance.
No, Counsel, I'm not doubting that, but you introduced it to refresh her recollection to the way a stoop looks, and she never said that she needed that.
I understand.
You can ask questions,
I
any questions
understand.
you want about the porch.
Does this picture reflect the stoop where he was sitting?
Yes, that's where he was sitting. He was sitting right there.
Are you talking about on the steps?
No, he was sitting here on the part of the step that leads out to the sidewalk.
Would you mark that, please? Was he fully clothed at that time?
Yes, he was.
Did he have a gun at that time?
No, he did not.
All right. Now, there came a second time that you saw him.
Yes.
When was that?
In Carlos K's home.
Okay. And what was the time frame since the time you saw him sitting on the steps, approximately?
When she came down, it was 1 something, so it was after she had called 911, which was around 1:45, because they called back after that, and they called my phone at 1:43. So it was after she had called 911 is when I saw him.
Did you see whether he walked to your house or drove to the house? Do you have any knowledge of that?
That I'm not sure of because I was in the house. I was in the living room.
Okay. Now, did you notice whether or not Mr. Smith's clothes were torn at all?
No, I mean, they're his lawn clothes. He had on his lawn clothes, his sweatpants and t-shirt, so.
Okay. Were you able to look at his hands or his wrist at all?
And he didn't seem like he was hurt or anything like that. He was there.
Okay. Did Anestia strike that? I have nothing further, Your Honor.
No questions, Your Honor.
You can go down, ma'am. Here you go.
Thank you. People move to bind over his charges and complaint warrant.
Your Honor, I'm not going to belabor the point because I think we may have had a discussion sidebar on this, but I just want to briefly make the record. The complaining witness testified that the defendant was standing on the porch at the time he had the gun and he fired the gun. And that is set forth in Exhibit C. Defendant would make the argument that under the recently passed Castle Law doctrine, passed by the legislature in 2007, that if the person has a right to be in their home, they do not have to retreat, and they can use less than deadly force to protect themselves. Now, I know that there has been clearly has been some evidence, it may have been conflicting, but we do have evidence that says that the complainant witness forced her way into the home and attacked the young lady.
What testimony do you have?
Well, what we have is from Miss Tatiana Grant saying that she heard the door slam.
No, she said the door slammed when it closed.
Okay.
She didn't say that anyone slammed the door. I wrote that down. She said the door slammed as it closed.
I didn't say that, Judge.
Okay.
I said the door
slammed. The argument that she did something that was aggressive in nature by stating that the door slammed, that's not the testimony that she gave with regard to that door.
Judge, you haven't allowed me to say what I want to say. You stopped me when I just said the door slammed.
I apologize, sir.
Thank you. I believe she testified that she heard that prior to Mr. Smith leaving the bedroom, he told her to stay, closed the door to the bedroom. The next thing she hears is running down the hallway. The door bursts open. The complainant witness is the first person through the door. Mr. Smith is behind her. She testified as to some aggressive acts by the complainant witness while she was in the bed. The Castle Doctrine, and it's stated in the Self-Defense Act, and I'm not going to belabor it, Section 780.972, quote, Section 2, that a person can use deadly force if they feel that there is great bodily harm to them or to another individual. Now, The legislature also, in response to the Self-Defense Act, has placed a presumption, and I understand there's a difference of opinion on it, but I just want to make the record, Section 78951, which says that the people have an obligation to defeat that presumption at the preliminary examination. We believe that there's a presumption that the Self-Defense Act applies. Not only do that, we also want to rely upon the common law statute of self-defense, and that statute is 768.21C, that a person has a common law duty not to retreat and can use less than deadly force in order to protect his or her dwelling or within the curtilage. Now, I've made much to do about Exhibit C, because Exhibit C shows that when the complainant witness said that she saw Mr. Smith with the gun, he was standing on the porch of the side door of his house. That is a part of the curtilage of the dwelling place, and therefore he was in his house and within the curtilage of the house pursuant to the statute.
So are you suggesting that anyone has an argument that with someone at their home that the person can grab a gun and shoot at them? If there's an argument?
No, absolutely. That's not what I'm saying. I'm saying that when there is evidence that a person forces their way into a house. Judge, I understand the court's view of the evidence. Well, as I said, the evidence on the record from Tatiana Grimes was that the complainant witness ran down the hallway, burst through the door, attacked her while she was in the bedroom, attempted to grab her at her legs, pulled the sheet, and testified that the defendant from the rear grabbed, put his arms around, was pulling her back, restraining her. That's the testimony of Ms. Grant. And I understand that it's different from the testimony of Ms. Thomas. But to say that there's not evidence in the record that there's an aggressive action by someone coming.
I said that your argument was that she forced her way into the house. I said there is nothing on this record that suggests that.
Well, Judge, I certainly believe that there is an inference that she forced her way into the house. When we, well,
pictures of a house that was gated. It had the security doors on it. So there is the inference. This was your evidence, counsel. You introduced the picture of the side door of steel gated bars on the door. Now, where does the inference come in that she forced her way through that?
Okay, it comes, well, looking at that isolated act, you may be right in what you're assuming, Judge, but there's more context to this. We've got a situation where the young lady destroys evidence, comes to the house uninvited. Judge, we have the text message. I think she testified she testified.
You're characterizing the evidence. Now, you asked her, did she delete something from her
Yes.
phone? You suggested it was for the purpose of destroying evidence.
Yes.
She may have taken it from her phone because it is something that is just not favorable. Not necessarily for criminal purposes, but sometimes people, facts, as we know, people take photographs of their naked bodies and they do things and they text pictures. Ma'am, I do not need your help. Okay? I don't need anybody commenting. Ma'am, with your head down. You're shaking your head. I don't need you to comment in any form. Now, if the comments are not necessarily just words, I don't need you commenting physically or verbally as to what I am saying. Now, what I'm saying is the context of what she indicated in that when she said, I need you to dick me tonight. Okay? Now, there is nothing criminal about that, but there is something embarrassing about it. So because she takes it out of her phone does not mean it was for the purpose that you're implying to create or destroy evidence. Because saying, I need you to dick me tonight, something that was entered earlier, does not mean, because personally, I can't see how it goes to the evidence one way or other with regard to her going over there for the purpose of having sex. So, and you're saying her deleting that is showing that shows that she is destroying evidence? Evidence of what? That she wanted to have sex with him?
Well, Judge, I'm not here to debate what inferences that the court wants to draw from the evidence. Okay, so, and I understand, but I certainly can, as a defense attorney, draw inferences that I believe are appropriate to the fact. And I understand the court may not agree with me, and I accept it. Okay, well, Judge, that's the inference that I'm making, and I'm trying to go forward with my argument. Okay? Now, as I said, there's context to these events that the young lady, the complainant witness, goes to the defendant's house, finds another woman present, testifies that she becomes upset about that, and makes the statement that the defendant voluntarily left her in the house. Now, someone can make the inference that that's true. The court can make the inference that what she said is true. Okay? Well, that's the testimony. I understand that. And you can, and purposes of facts are to draw inferences from them. That's what we do. That's what the jury does. That's what everybody does. Okay. Judge, let me just get back to the statutes, and then I'll be done. As I said, common law right to self-defense, 768.21c, no duty to retreat, and it extends to the dwelling and the curtilage of the dwelling. And I'm making the point that at the time he had the gun, he was within the curtilage of his house. Self-Defense Act, 2007, 2007, which expanded the common law self-defense and says that deadly force or less than deadly force can be used by a person when they are in their house or in the curtilage of the house. Once again, testimony from the complainant witness, he's standing on the porch. And he can use it to not only protect himself, but protect another individual when we have evidence of that. Now, also there's a presumption that he acts accordingly, set forth in 780.951. Well, Judge, Judge, if you look at the heading,
That would suggest that anytime anybody has any shooting, there's a presumption that it was in self-defense. It does not say that.
Judge, I just want to indicate from the statute, the heading of the statute, presumption regarding self-defense, section 780.951. That's what the statute says. That's the heading of the statute. Okay. And I'm saying that they have to overcome that presumption at the exam. Okay, and I don't think that the people have. You know, I would ask the court not to bind over on felonious assault on the grounds that the protection provided by the Self-Defense Act and the common law right of self-defense. I would also ask the court not to bind over on domestic violence, because I think from the evidence we have the complainant witness who is entering the room, the bedroom of the defendant without his permission.
Domestic violence is a misdemeanor. It's not subject to prison examination.
Pardon me? Oh.
Domestic violence charge is a misdemeanor. It's not
Fine.
subject to prison
Oh,
examination.
fine.
It has nothing to do with that.
Fine. I'm finished, Judge.
Your Honor, what counsel negates or doesn't mention in his argument is in order to use self-defense, one must have the honest and reasonable belief in order to use deadly force of death or great bodily harm being innocent. Where is there any evidence that this defendant or anything on the record that he feared death or great bodily harm? He is confronted with an unarmed woman who physically the court saw is smaller than him. She has no weapon. There is nothing on the record that suggests that he had any fear of death or great bodily harm. Furthermore, his actions after the shooting are inconsistent with someone who believed they were the victim of a crime, because he did not call the police. He did not ask anybody to call the police. The first person he saw was in fear of my life. What did he say? Domestic violence, and I shot up her car so much that it wouldn't even move. Your Honor, there is nothing on this evidence to support any type of self-defense and or even if you want to talk about defense of others, even assuming arguendo that there was an attack on Tatiana Grant. That attack ended once he tossed her outside of his house. He was in the house, came back in the house to get a gun. At that point, there was nothing to defend against. He was already in his house. He and Tatiana Grant were safe. They had 2 cell phones available to call to get aid, and he chose, I say he chose to go outside with a deadly weapon, an assault rifle, in a residential neighborhood and just shoot up that car and shoot at her. Your Honor, I think a bind over is appropriate based on this evidence.
Just briefly, Your Honor. Once again, as the court has often said, the inference of the 9/11 call doesn't mean that a person is obligated to call the police. Does not establish that the fact that the person is not being threatened simply because they don't call a 911. Now, we also have testimony that after this event occurred, that the complaining witness went and picked up a chair. So there were events that occurred after the alleged altercation in the house that were threatening by the complaining witness.
Reserve testimony, evidence, as well as argument. The defense position is that Mr. Virgil Smith, in his home and upon the curtilage of his home, has an absolute right to defend himself. Well, there are principles that stand for that, but there are things that must come first. The people have indicated that there has to be an honest and reasonable belief that the person is at risk of great bodily harm or death, which is absolutely true. In other words, you cannot respond with deadly force to a person who is presenting just a simple battery. And certainly, in the case of this, what we have is obviously we had Miss Thomas, who comes to the home of Virgil Smith, and it is clear basically from the testimony and any reasonable examination of evidence that she came because she thought that she was spending the night with him. Yes, she was surprised to find that someone else was there, and quite frankly, I don't know too many people who would not be upset. But the question comes in as to, one, if Ms. Grant was put at risk, you certainly would have to ask if someone had their ex-wife come over who knew was coming over and knew once she got there that when she was upset, why would you let her in the house? Certainly you would let someone in the house through your security gate, which is designed to keep undesirables or threats outside of your home. Why would you let someone in unless, one, you didn't feel that they were a danger to you? Because you opened the security gate, again, something that is designed to keep something that would be harmful to you outside of your immediate presence. He obviously, at that point, if he opened the door, and there's testimony that he did, he allowed her in, so obviously he did not feel threatened at that point. There was testimony from Ms. Grant that she heard steps of running towards her, and certainly her testimony somewhat more when she first indicated that she jumped on the bed at her feet, because her testimony didn't initially say that Mr. Smith grabbed her. She said she jumped on her bed at her feet and grabbed the sheets and pulled the sheets off her bed. Later on cross-examination, she indicated somewhat, or she presented a picture that was somewhat different, because she certainly did not indicate initially that she felt threatened at all. In fact, her words were, "I was just shocked." On further examination, it became frightened, fearful, but no actions that would be consistent with a person that is fearful. There was no phone call, there was no threat. She only indicated that she was planning on getting out of there because, there was some mess going on in there, and she didn't know, she wasn't going to be a part of it. She indicated she could not see anything, and she said, "I could not see anything," and she asked for her contacts, which is interesting. not in the fact that she asked for the contacts, but if Mr. Smith was so enraged at what was going on, he took the time to stop to go get the contacts for Miss Grant, gave Miss Grant her glasses, her contacts, and then proceeded to go find a weapon to go outside. That is an act that is inconsistent with a person who feels that they're at threat, that they're at risk, or they're even in fear. I'm going to give my girlfriend her contacts, then I'm going to get a gun, and then I'm going to go outside, and I'm going to confront a person who is outside, presumably because there's been no testimony that Miss Thomas was armed, and Miss Thomas was nowhere close to him because we saw the photographs of the home. The side porch is nowhere near the front of the porch. Ms. Thomas indicated that she grabbed a wicker chair, which I cannot, in my mind, reasonably make some type of determination that that is a dangerous weapon or an object that can cause a person to be in honest and reasonable fear of great bodily harm or death, particularly if they're nowhere near them. If, in fact, and looking at the photograph, the distance appeared to be something like 20 feet or more. Certainly, a person with a wicker chair cannot inflict harm on a person from that distance. If, in fact, there was testimony that Ms. Thomas had a gun, certainly you can do that. But I don't know anybody that can hurt someone from 20 feet away with a wicker chair, particularly when you have to come out of your house armed with an AR-15, which we all know to be a military-style assault weapon, a weapon that some of us who were in the military had when we were going active duty in the armed forces. It is a dangerous weapon. And we have to look at all of the acts in this case. If Mr. Smith was so threatened, why would he shoot up the car? I've never seen a parked car be a danger or a threat to anyone. If someone was behind the wheel and they were driving a car at you, it would be one thing. But a parked car without a driver, without the car started, certainly that car did not present a threat or a danger to Mr. Smith. So you cannot say that he was acting in self-defense when he did that. You cannot say he was acting in self-defense when he was shooting at or in the direction, and I don't know that he was shooting at her, because the testimony was, one, that the weapon was being fired in the air, and then there were some additional shots. And Ms. Thomas did indicate the weapon was pointed in her direction. But certainly, I think most people who see a weapon pointed somewhere in the area assume it to be pointed at them. I'm not saying it was or it was not. But certainly, for felonious assault, you do not have to shoot at a person. Felonious assault is simply an offer to engage in assault. You can present a weapon in a threatening fashion. The weapon does not have to be fired at all for it to be a felonious assault. So if he was firing the weapon in her direction or firing it in the air with a specific intent or an action that would cause a reasonable person to be in fear, that is the elements of a felonious assault. Does not have to be, because if, in fact, it was fired at Ms. Thomas, and certainly the people thought they could prove that charge, then the charge would be assault with intent to murder, not necessarily felonious assault, which does not require the firing or discharge of a weapon in any form. So, with regard to self-defense, it would be a stretch for this girl to make some type of determination, and just so I'm clear with regard to something that the defense counsel said, he said people must defeat the presumption of self-defense. Well, first there has to be something that suggests that an act occurred in self-defense, and there's nothing that I heard on this record that would suggest that Mr. Smith was ever put in a position where he could fear or have a reasonable and honest belief that he was at risk to great bodily harm and or risk of death. So, this court has heard sufficient evidence for a probable cause to believe the charges would cause one. We give testimony on the record. It was stipulated to the value of the vehicle as being $35,000 or somewhere in the area of $35,000. The statute only requires that the property have a value of $20,000 or more, and it was done in a malicious manner. I don't know how many gunshots or how many shots were fired into that vehicle, but I heard that it was well more than something that would have occurred by accident. So certainly there's sufficient evidence to probable cause standard to believe that malicious destruction of personal property did occur due to the city of Detroit. Probable cause to believe it was committed by Mr. Virgil Smith. Count 2, the assault with a dangerous weapon, have already indicated that a person only has to act in a fashion consistent with doing an act that would cause a reasonable person to be in fear. A person does not have to be in fear. A person does not even have to know that a person is doing something. In fact, so in other words, if I had my back turned and someone was pointing a weapon at me, other people could testify to that act, and that person would still or could be guilty of the charge of felonious assault, because it would be an act that would put a reasonable person in fear. Not that the person has to know, or that the person could believe they're Superman and like, you can't hurt me. It does not relieve the person of the act from their consequences or liability. With respect to count 3, weapons, felony, firearm, certainly the requirement for that is only that a crime was committed while a firearm is in their possession. That, again, does not require that a person fire a weapon, discharge a weapon, or do anything with it other than the fact that they have accused of committing a crime and they have a firearm in their possession. So certainly there's sufficient evidence to a probable cause standard to believe that charge was committed in the city of Detroit. Count 4 is domestic violence of the 93-day misdemeanor. That is not subject to a preliminary examination. That would be a follow-on charge, because this court does so find that there is sufficient evidence for a finding that Mr. Smith will be bound over the third circuit court for further proceedings. The arraignment on the information will be July the 9th.
July 9th, sir?
Bond is continued. This matter is adjourned.
Thank you, Your Honor. Wait.
Oh, Mr. We do need to do a couple of things. We had a couple of sidebars, and we need to make the record clear of the things that were discussed in sidebars.
Okay.
Yeah, I just want to get
Here.
All right.
All right. Certainly, there were a couple of sidebars, and I think it is always appropriate to place on the record what was discussed in sidebars, so we can ensure that nothing was said or done or anything told was done. The first time we had a sidebar, I believe it was
There was one sidebar that dealt with the questions about whether the victim's father had ever threatened the...
Yes, thank you so very much for reminding me, because I did not write
Yeah,
There was a question that was put to the witness, where if in fact the father of Miss Thomas had threatened to kill her, went to the back and discussed that matter.
I think it was threatening to kill Mr. Smith, not to kill her.
I thought you said her.
To kill Miss...
The
her
way
father.
the question was put, it was not clear to me, but certainly there was questions in my mind as to if that was appropriate and if it was something that should come forward. And we did discuss that in rear in sidebar, and certainly there was nothing that I heard with regard to that would suggest that this third person was there, or there was any allegations or anything that suggests that that would have a factor or something that would be admissible in this matter. So that was that first sidebar discussion. Was that all that was discussed with regard to that?
Yes.
Yeah, I don't, yeah, I
Yes.
mean, I would agree with that.
Okay.
Yeah.
I think the second issue had to do with the Facebook page, and I believe my objection that it was not relevant, and so...
There was a Facebook page that she wanted to introduce, where the complainant indicated that she made a Facebook page caption stating something to the effect, had to upgrade, and said something about taking advantage of an opportunity. So, certainly, I don't know, because this is something that happened after the fact, and if in fact, something, you know what, if a tornado knocks down my house tomorrow, I will take advantage of that opportunity to upgrade, but it does not mean that that had anything to do with her act earlier with regard to setting it up in any kind of form or fashion. I think people take advantage of disasters all the time. You see people take advantage when a person dies of the life insurance or things like that. So certainly her mindset as to, like, my car was shot up, I'm going to get a new one, I'm going to take advantage of it. I don't see anything about that that would suggest that the person has done anything wrong, because that comes well after the fact.
I thought it was, in all deference to the court, I thought it was an authentication issue. She identified it as her, and I thought that the reason why the court was not allowing it, it was that the court suggested people could falsely create space, but my understanding was authentic. I'm going to rely on what the court said, but I'm just making my record. Well, as I said, I'm just simply saying, Judge, my understanding was authentication, lack of authentication was the issue as I recall it. But
after she authenticated, my objection was relevant.
Well, that may have been true. I'm just saying that authentication was a part of it.
No, that was an objection earlier, but when she stated that is my Facebook page and that is my post, there was no longer a question about the authentication. It was only a question then as to admissibility and any relevance. The fact that somewhere later, because her car was destroyed and totaled, she obviously had to get a new car.
Well,
I don't see anything wrong with a person trying to make a determination to upgrade from that.
I'm not really talking about what she testified to. I'm just pointing out when I thought we were at sidebar when we initially were discussing it. The issue of authentication was the problem with it. However, when she came out on the stand,
She said that before.
that's not how I recall it, Judge.
She said she authenticated it and said it was her.
That's not how I recall it was. The Madam Prosecutor said that he has a Facebook page. Can we have a sidebar? Before we ask any question.
That's not the way it goes, though, because you asked the question, she objected, and I said that you can ask the question if it is, because she said there was a question of authenticity. I said you can ask the question if it's hers, and he did. And she said, yes, that is my Facebook page, yes, that is my post. Then it was a question as to why is it being admitted.
I have nothing further, Your Honor, on that issue.
And I think that includes all the sidebars. The last sidebar we had dealt with the calling of witnesses, and I think we did handle that on the record.
The last sidebar is absolutely correct. We talked about the witnesses that were known to you but not presented to the people, and we put that on the record.
Yes.
I only have to ask, was that all that we discussed in those sidebars, and was there nothing else that someone could say, well, later we talked about this in sidebar?
No.
That covers all.
I think that covers all that I know of.
Thank you.
Thank you, Judge. Okay. Thank you, Lisa. Yep. Yep. I'll call you. How soon can I call you?
Well, next week.
Okay. Is that next week? Next week? Or next week? Yeah.
Our arrangement